was made possible in 1993 by an amendment to the Coal Mines Nationalization Act. Before that, only government companies could be allocated coal blocks. But after 1993, or since 1993, when the private sector entered the power sector and iron and steel, sponge, coal washeries, it was necessary to make an amendment to the law so that these firms could come in. And the problem was, and which the Supreme Court pointed out in its judgment, that the procedure was quite arbitrary. There were no set guidelines for selecting companies, or for example, if many companies were bidding for a single coal block, there was no rational procedure to decide which company out of many would be allocated that block and why. Obviously, there was a whole lot of corruption in it. Companies which were wholly ineligible were farmed out coal blocks. In many cases, the size of the coal blocks or the amount of coal which these blocks had was far in excess of what many of these companies required. The court held that these allocations violated some sections of the Coal Mines Nationalization Act of 1973 and the Mines and Minerals Development and Regulation Act of 1957. So those were the grounds on which these allocations were held illegal. The immediate challenge is that what will happen to all those people who have been allocated these coal blocks. Some have already started making use of them. Because of this kind of uncertainty, coal prices might shoot up. There might be disruptions in supplies from other countries who just might want to wait to see where things go so that they can bid up the prices of coal. Devising a regulatory challenge which will not be subject to a legal challenge at a later date and all the uncertainties which accompany the process, that's the big challenge in front of the government.